Tonight on Greater Boston, coming to you from the Boston Public Library, as former President Donald Trump's legal outlook goes from bad to worse, two of the top legal minds in the country, former federal Judge Nancy Gertner and Harvard Law's Laurence Tribe, are standing by to weigh in. But first, a little scene setting. You probably heard about the New York Attorney General's announcement that she's filing a civil lawsuit against Trump and three of his kids and the Trump Organization, accusing them of defrauding lenders, insurers, and others over the course of decades. Staggering, she called it, staggering enough to send a criminal referral to the U.S. Attorney in Manhattan. You also may have seen the appeals court ruling out of Atlanta that cleared the way for the Department of Justice to continue its criminal investigation into classified documents found at Mar-a-Lago. But those are far from Trump's only legal problems. Some you're likely familiar with, like the House Select Committee's investigation into his involvement in the Capitol insurrection and the grand jury looking into his efforts to overturn the election in Georgia. But there are several others that might not be on your radar, like the likely lawsuit coming from one of the several women who've accused Trump of sexual assault, journalist Jean Carroll. The ongoing battle over his tax returns, lawsuits from multiple Capitol and D.C. police officers stemming from the insurrection, the lawsuit his niece, Mary Trump, has filed, claiming he defrauded her out of millions of dollars in inheritance. And there are many more, but in the interest of time, I'll stop there to ask, are the walls finally closing in on this lifelong escape artist? Here to answer, Nancy Gertner, retired federal judge, senior lecturer at Harvard Law School, and Harvard Law professor emeritus Laurence Tribe. Judge, Larry, good to see you both. Thanks so much for your time.
Good to see you.
Good to be here.
Judge, can I start with you? Let's not leave people in suspense. Let's start at the end. Has Trump used up all of his legal lives? Has the law finally caught up with him?
It's a general question. I think that there are still lies to address the New York suit against him. I mean, I think there's still stuff he can say. There are defenses there. That's the lawsuit that says that he dramatically overstated his properties.
Right, the Letitia James thing.
He'll claim that somebody else did it, that he wasn't personally involved. And my favorite argument is he says that in all of the documents that he filed, there was a disclaimer saying, go look at it yourself. You should look at the records yourself. And I was thinking, I'm going to go sell a Rembrandt and say that it's real when, in fact, I just sketched it together, and say, you can look at it yourself. But that's usually not enough. So I think there are defenses in the civil lawsuit that don't exist. But I think he's out of luck on the classified information stuff. The 11th Circuit decision was pretty clear.
Is his legal goose cooked, Larry Tribe?
I think it's cooked and overcooked. Take, for example, Letitia James' remarkable 220-page complaint. I finally read through it. All of the kinds of defenses that Nancy Gertner is pointing to, she has fully anticipated. The defenses that say, I didn't know about it, are met by paragraphs in the complaint, making it very clear that things were done exactly at his direction. And in all of the criminal cases, things are just winding down. The 11th Circuit slapdown of Judge Cannon's remarkable ruling is excoriating and crushing, and it essentially gives a green light to Merrick Garland and Lisa Monaco to go ahead with the investigation and prosecution of the offense of espionage. And in the meantime, there have been 40 subpoenas served that show that Merrick Garland has not been asleep at the switch in terms of the attempted coup and the insurrection. So the walls are closing in.
Let's take these piece by piece for a few minutes if we can. Let's start with that appellate court ruling. Two things stuck out to me, Larry Tribe. One, the two of the three judges on the appellate court were Trump appointees. The second thing is that Trump's argument that he declassified things. Well, actually, he made it yet again on Sean Hannity last night. Here it is.
If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it.
Just by thinking about it. It seems to me that the whole classified information is off the table. And if I'm right about that, Larry Tribe, does that mean that essentially this judge who you tweeted about being, quote, in the tank, that essentially there's nothing of consequence left before her?
Well, actually, what's left before her is one trap after another for Donald Trump. What's happening is that because all of his legal defenses are just nonsense and they are collapsing one after another, he's resorting in public statements to things like the telepathy defense, the defense that I just thought myself out of this dilemma. None of them work, and he is incriminating himself over and over and over again. In fact, just a few hours ago, the judge who is the special master in this case, Judge Deary, issued a no-nonsense order forcing Trump to specify through his lawyers, point by point, exactly which documents he says are subject to executive privilege within the executive branch, which documents are subject to executive privilege from claims outside the executive branch, which things do you say are personal. There's just no room to hide. And all of this nonsense that he sputters to Sean Hannity is just getting him in deeper and deeper trouble.
Well, there was once the Twinkie defense, now the telepathy defense. Staying on the special master, or as a satirist who Larry Tribe and I both admire, Andy Borowitz, said, since Trump isn't happy with the special master, he wants an extra special master. I don't understand. If the classified documents are essentially segregated as per the appellate decision, Judge, what does it matter what happens in front of the special master going forward?
You mean with respect to the rest of the documents? I mean, the government can make its case on the classified documents that they have. They have, what Judge Deary made it clear is that the telepathy defense doesn't work. And now he's saying, now he's essentially saying to Trump and his attorneys to put up or shut up. They had almost 18 months to say, hey, this is personal. Hey, this isn't classified. Hey, and didn't. And now that they claimed that they didn't want to identify any of that because it could sort of deal with their defenses at trial. I mean, that's an extraordinary.
Right, but let me just say, to get specifically to your question, she still has, Judge Cannon has before her, the possibility that he's going to submit to Judge Deary statement that the following classified documents are actually protected by executive privilege. Like there might be a note on something about what his lawyers advised him. I doubt it, but he has that opportunity. He also has the opportunity to say that some of the things are, attorney-client work product, all of that stuff. He might say that 18 of the 11,000 documents should not be in this pile, but that pile. But the bottom line is that apart from his underwear and other stuff like that that's in there in the boxes, apart from that, it's all government property. So even if he wins various claims, the documents don't go back to him, they go to the National Archives. So it's really a dispute about whether things are going to go to the archives or to the Justice Department. And he's now resorted to saying the archives is in the tank for the Biden administration. We can't trust the National Archives. They're a bunch of lefties. He then says the reason that the FBI was so vigorous in going after Mar-a-Lago is, listen to this, they were going after Hillary Clinton's emails. The email defense in addition to the telepathy defense. So it's really pathetic.
Judge Gertner, I want to move to.
He can try to do delay. I mean, in other words, Judge Deary is going to find X or Y, and then he could try to appeal to Judge Cannon. What is interesting about the 11th Circuit defense is that I would imagine that when she touches the case again, she will be chastened because the 11th Circuit found her legal argument to be absurd and the factual findings to be absurd.
Can we just
just today, just to reinforce Nancy's point, just today, about 3 hours ago, chastened, she issued a one-page order saying, my bad. She basically took back the stuff that the 11th Circuit had told her was wrong.
Can we just spend a minute on the Letitia James thing, starting with you, Judge Gertner? I assume most people know when you take a Fifth Amendment, like Trump and one of his sons did hundreds of times in this investigation leading up to the civil litigation yesterday, while that kind of thing can't be used against you in a criminal trial, it can be used against you by a jury in a civil trial. You've presided over many of those. How powerful is it to have the state telling a jury that the President of the United States, the former president and his kid, did take the Fifth Amendment hundreds of times?
Well, the video of him taking the Fifth over and over and over again is chilling. I mean, there's no question about that. By the way, the other thing about the civil case is that it's easier to prove for Letitia James.
Right.
Because it's only by a preponderance of the evidence. It's definitely, more than 50%.
Well, that's what I wanted to ask you, Larry Tribe, is she did make a criminal referral to both the Internal Revenue Service and the U.S. Attorney in Manhattan. You've said you read the 200 pages, which is 200 pages more than I've read. But based upon your reading, with that higher standard of proof that's required in a criminal proceeding, she thinks it's been met based upon her press conference yesterday. Do you?
I do. I think that the federal offenses of wire fraud and other forms of fraud that he committed in order to basically prop up his empire, all of those things are serious federal crimes. And the evidence, whether you use a preponderance standard or a reasonable doubt standard, there's no reasonable doubt that I can see. And all of his attempts to raise doubts by postings on Truth Social, ironically named, they're not going to work in a criminal or in a civil case.
Larry Tribe, I was never a student of yours in the classroom. I'm a student of your Twitter feed. And if I were to guess what you consider to be the most serious criminal threat to Donald Trump, it seems to me that you've concluded that the espionage charge around the documents is practically a slam dunk. Would I be right in that analysis?
Yes, I think you're right. It doesn't mean that the others aren't strong. I think that the Fulton County DA has a very strong set of state criminal offenses that she is very likely to indict on, and they're quite special in the sense that no future president of the United States can pardon him there. That is, he's sort of counting on dragging things out so that the federal prosecutions are going to go away. They won't have been fully finished by the time either he or DeSantis or one of his other acolytes sneaks their way into the Oval Office. But even if that's true, and even if they get a William Barr type attorney general, Letitia James is not going anywhere. And her successor in Fulton County is not going anywhere. So he, I think, faces jail time one way or the other, and he's not going to be able to get out of it, even if the Republicans win the midterms, which they may not, and even if they take the presidency in 2024, which they may not.
I want to ask Judge Gertner about Fulton County in Georgia, but before I do, he faces jail time. Does that mean that he's convicted in your mind and would face jail time? Does that also mean you can envision a judge sentencing a former president to jail time?
Larry
Tribe, Larry Tribe mentioned it. What's the answer to that, Larry?
Okay. I think, yes, it depends on the judge, of course. Some judges, like Judge Cannon, are in the tank. They would give him a gold star rather than jail time.
Well,
Another judge
Gertner,
would give him an orange jumpsuit.
Well, I think it will be hard. I mean, if it's only the classified documents issue, I think it's hard.
Nancy, why do you say only? These are national security defense.
I know, but if you look at what people have gotten for those charges, now there's nothing comparable. It has been usually a box or two, or I shared it with my girlfriend. So there's never been a case of this many over a sustained period of time without an excuse. But I would say that, any judge would look at this differently than it looks at every other case.
Well,
That's why it's interesting when the special master stuff came up with Judge Cannon, I could see any judge, even one in the tank, granting a special master, but narrowing the review to attorney-client privilege. Take a look at that again. So I don't know what a judge would do in this situation, but it's certainly different than any
soft, Nancy. I don't get it. I mean, I think as a judge,
soft on everybody, though.
Well, that could be, and I'm supposed to be a softie, but my God, when Judge Cannon said that he's the president and that makes him special, one of the cool things is the 11th Circuit said, no, a former president is not different in that way. And although he's trying to gin up the idea that there'll be blood in the streets if you go after me, I think he's just daring the legal system to prove that it really can stand up to him. And I'm hoping.
I don't disagree. I think that the classified information stuff is a slam dunk because there is no explanation, no excuse, and he had multiple opportunities to return it. The question is what to do with a conviction.
Well, if I may be the third man in here, you mentioned the Fulton County prosecution. Here's Fannie Willis, the prosecutor there. This is on September 15th. The allegations are very serious. She doesn't mention Trump in particular. If indicted and convicted, people are facing prison sentences. I have to say, as someone who's listened to that call between the president and the Secretary of State in Georgia, I'll tell you, I've never heard a clearer and more direct effort to overturn an election at any level of government. And it seems to me, again, as the third person in, that might lead to prison time. Can we stay on the feds, though, for a second? Larry Tribe, first with you. There's this informal 60-day rule. We're within the 60 days now. The theory being, and I'll characterize it as best I can, that we're not going to prosecute anybody, go against anybody that close to an election, so it's not seen as affecting an outcome of an election. Obviously, Hillary Clinton probably is paying attention to that. So assuming Merrick Garland, your former student, adheres to that, the election is over. The next day, the target of these investigations announces he's running for the presidency of the United States. It would seem to me that a far more serious conundrum for Merrick Garland than 60 days up to an election is indicting a guy who has just announced he's running for a second term as president. Am I wrong?
Well, I don't think you're wrong in general, but I think you're wrong about Merrick Garland. He is a no-nonsense guy. When he made a speech, several, but in one of his speeches he made very clear that he just doesn't think it makes a difference whether somebody is running or not running for the presidency. All citizens, all civilians are the same in terms of the law. That's the thing that he believes with all his soul. He tears up when he talks about his family's escape from the Holocaust and what he loves about this country. He loves the rule of law, and that means that all of these threats and all of this hand-wringing about how extraordinary it would be to imprison or sentence a former president is just not going to detain him, and he's certainly not going to be detained by the manipulative ability of Donald Trump to pick his moment for announcing when he's running for the presidency and then say, gotcha, you can't go after me now. Merrick will not fall for that.
You know, Nancy Gertner, can I return to the little dispute you and Larry Tribe had a minute ago? Let's assume you're the judge in every one of these potential criminal prosecutions, and the former president of the United States is found guilty in every single one of them. Can you imagine not sentencing him?
No, you're right. I mean, I can't imagine not sentencing him to time. The question is how much. If you look at each case in isolation, that comes to one conclusion. But if you link it to the wider story, and if, for example, any of the documents are tied into the wider false elector story, et cetera, then, I mean, that would be, I mean, you're right. It really is to depend on what the pile's going to look like. But I think it's an illusion to, I think Merrick Garland is going to indict. I have no doubt about that. I think that particularly in the records case, he's going to be, Trump is going to be convicted. I think the only question will be what a judge does at sentencing and what the pile of evidence looks like. That's really the only issue.
Larry Tribe, can you explain something to me also? I am embarrassed to say I didn't know until the January 6th hearings about the provision in the 14th Amendment barring someone from federal office. Let me read a piece of it. No person shall hold any office, civil or military, under the U.S. who shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. I guess I understand that if he's convicted relating to January 6th, convicted, that he would be barred under this provision in the 14th Amendment. What other criminal, first of all, am I right? And secondly, what other criminal conviction that's potentially on the table might lead to a barring Donald Trump from seeking the presidency again? Any?
Probably not. I think it's only that one, although there are other statutes, conviction under which would lead to disqualification, but the constitutionality of those statutes is at least open to arguable challenge. You can't challenge the constitutionality of Section 3 of the 14th Amendment. It's part of the Constitution. And only a few days ago, a very courageous judge in New Mexico decided to remove a county commissioner from office because he was guilty of involvement in the insurrection on January 6th. He was, in fact, not convicted of insurrection. He was convicted basically of trespass. But you don't have to be convicted criminally in order to be found by a judge, probably by a preponderance of the evidence, to have been an insurrectionist who then cannot, under the Constitution, hold any office under the United States.
Wait a second, is that a separate proceeding with a different standard of proof? Meaning,
No,
what's that?
It's not clear. That is, some people have argued that language in the 14th Amendment is self-executing. But I don't know what that means. I mean, you can't just say Trump fomented the insurrection, therefore he can't run. Somebody with competent jurisdiction has to make a determination that he did that. Now, the House of Representatives already, in impeaching him, made that determination. I don't think that's going to be enough. I think we need someone like Nancy Gertner as a sitting judge to decide by a preponderance of the evidence that he probably was involved in giving aid and comfort to or directly fomenting the insurrection. And I think at that point, that part of the 14th Amendment would kick in. There is a proceeding now challenging that ruling by the county, by the district judge in New Mexico. It's going straight to the New Mexico Supreme Court. I've looked at that. There are 5 judges there. They're very solid, serious judges. I think they may well affirm his exclusion under that clause.
Can we end with a non-legal reaction to both of you? Speaking of aid and comfort, the president has given aid and comfort in another setting to QAnon. And for people at home who don't know about QAnon, this is an organization that believes some satanic bunch of pedophiles are leading the United States. I'm going to show you what Donald Trump retruthed, I guess is the verb, on Truth Social. And as you can see there, on his lapel, he's wearing a Q, the symbol for QAnon. The storm is coming is their line. And for the people who don't know, the storm is Trump's final victory when his opponents are tried and potentially executed on live TV. Starting with you, Judge Gertner, it seems to me that this is sort of the lead up to January 6th, the sequel, that he's basically preparing his people, the QAnon people and other like-minded people, for him to be indicted, charged, whatever, and to do, hopefully, from his perspective, on a grander scale, what they did on January 6th. What's your reaction to that posting?
Well, I mean, I didn't see that particular posting. I saw the salutes
At the rally.
That he gave, which are chilling and horrifying. I mean, there's no question that to his sort of core base, this looks like, unsolicited attacks on their former president, and as opposed to finally, as you described it, the walls closing in on him, finally. But I mean, it's chilling. It's absolutely chilling. I think the most stunning issue is why we hear now that the Republican Party, some members of the Republican Party are tilting away so as not to be allied with him, but not enough to my taste.
Laurence Tribe, it was a call to action when I saw it. Am I wrong?
No, I think it's worse than chilling. I mean, quite apart from the basically Hitler salutes that we were watching in response, he was using the direct language of go get them. He was basically saying, if they come after me, you go after them. And I want you to do it vigorously and violently. He is right now giving aid and comfort to another insurrection. He is disqualifying himself under Section 3 of the 14th Amendment. It's not self-executing, but any judge with any integrity would find that what he is doing disqualifies him from ever being president of the United States or holding any office, dog catcher on up.
Well, let me thank one judge with a lot of integrity, Nancy Gertner, Larry Tribe, you as well. As always, I really appreciate your thoughts.
Thank you.
That's it for tonight. Please come back tomorrow for Talking Politics. The Orange Line is back up and running, but the T's troubles don't end there. And neither Governor Baker nor the legislature ever seem to take a political hit for them. Why? Adam Riley and his panel will dig into that, plus the governor on immigration, Jeff Deal, and election denialism, and more. That's tomorrow at 7. I'll be back next week. Thank you for watching, and please don't forget Ukraine.
Hey folks, Edgar B. Herwick III here from GBH's Curiosity Desk, where you ask questions and I find answers. Today, how did this 12-foot bronze pear end up at one of Dorchester's busiest intersections? If there are two things you cannot spit without hitting in this town, it's a Dunkin' Donuts and a historic statue. Now, most of them are pretty by the book. Paul Revere atop his horse in the North End, martyr for religious freedom Mary Dyer sitting contemplatively outside the State House, Celtics coach Red Auerbach chomping on a cigar on a bench in Quincy Market. But artist Laura Baring-Gould had a completely different kind of statue in mind for this spot in Dorchester, Boston's most diverse neighborhood. An enormous pear.
Doing public art is always a tricky endeavor. Because who's the public? What's the public?
Ladies and gentlemen, I present to you a small, randomly selected, non-statistically significant sample of the public. Do you have a theory as to why they put a giant pear here?
There's a book called James and the Giant Peach, and the mayor in 1963 read the book and decided to one-up it.
I don't know. It's doing its job. It's doing its job.
I passed by with my granddaughter, and she asked me about this pear, and I don't have an answer. I say, I don't know what does that mean. I would like to know what is that.
All right, you gonna tell me why we have it here now?
Pears were once grown in abundance here, and one variety was actually created here by a guy named Thaddeus Clapp. Now, he took a Bartlett pear and crossed it with a Flemish beauty to create a brand new pear unique to Dorchester. The variety was aptly named Clapp's favorite. But that's not the only reason for this enormous fruit. Baring-Gould settled on this pear idea after months of research and countless conversations with people all around the neighborhood that revealed a rich agricultural heritage here that cuts across culture, class, and time.
I see in the Vietnamese communities people growing cucumbers in their gardens. And then as you cross over the Cape Verdean communities, people are growing beans.
She also learned about the neighborhood's 17th century farms, its 19th century orchards, and saw tons of 20th century photos of kids playing in front yard fruit trees.
And it could also be this unlikely symbol. What's a pear doing in Dorchester? Why a pear?
Around the pear are 10 smaller sculptures honoring Dorchester's unique history through everyday objects. There's the Three Sisters crops, squash, corn, and beans, vital to the area's indigenous peoples. There's dog tags honoring local veterans, a triple-decker house, and more. But it is the pear that looms largest here, and Baring-Gould sees it as a fitting metaphor for Dorchester. A sweet, tough-skinned hybrid fruit, something wholly new, only made possible by cross-pollination.
Thank God, now I know what I'm gonna say to my granddaughter.
So, there you have it. Don't forget to like and subscribe, and perhaps most importantly, let me know what you are curious about, because hey, I might just look into it for you. I'm Edgar B. Herwick III. Stay curious out there. Oh, pretty good. This is a tasty pear.